So I'm pleased to present our lead speaker tonight, Jacob Eisler. He is the James Edmund and Margaret Elizabeth Hennessy Corey Professor at Florida State University College of Law, where he specializes in constitutional law and law of the democratic process. He received his J.D. from Harvard Law School and his Ph.D. in political science from the Harvard University Department of Government, and a BA in English and political science from Williams College. He's the author of The Law of Freedom, the Supreme Court, and Democracy, which was published in 2023. Welcome, Jacob Eisler.
Good evening, everyone, and thank you for coming. Thank you to Grace for this lovely invitation, and to everyone else at the Gadsden Centers who helped make this show possible. Not to sound like too much of a shill, I know the first thing I'll be doing once I'm done with these remarks will be joining the Gadsden Art Gallery, and I don't think I'll be the only one. And above all else, thank you to Julie for creating the wonderful artwork that is bringing us together tonight. For reasons this talk will build to, Julie's work is an especially wonderful illustration of the potential of art. Aesthetically, it's beautiful, but also as an expression of the potential of art to be a form of intellectual engagement and a tool of social transformation. We're very lucky to host this exhibit. So, to frame Julie's work, I'm going to talk a bit about law and art. Now, at the outset, this caused me a great deal of chagrin as someone who had dreams of being an artist early in my life, before my lack of talent kicked in. They might seem like very different things. Art is the height of human endeavor. It's the expression of human creative potential. Collectively, it is the place where we express our most precious and liberated values as in a society and give them tangible form. At a personal level, it's the domain of self-expression, organized through beauty and through liberated reason. A person freed from constraint and seeking to flourish makes art. It is the untrammeled expression of the best of human capacities. There will, I think, be art in paradise. And in a society of angels, the creation of art will be a central endeavor. And then we turn to law. To continue the analogy, James Madison in the Federalist Papers said that angels would need no government, and thus by inference, no law. Government is fundamentally about law. And in the most famous law review article of all time, it's called The Path of the Law, the citation is 10 Harvard Law Review 457, for those of you who are keeping score at home. Oliver Wendell Holmes described how law must orient itself to considering how the worst in society behave. This is called the bad man theory of the law. Law is about policing bad people. Law, stated bluntly, seems like a grim necessity, a pragmatic tool by which we coordinate our society. In paradise, law won't be necessary because the scarcity and the conflict of this world won't be present, won't be needed to be policed and regulated. But in this world, a world that does have scarcity and conflict, we need law to provide us with the structures to do things like create art. Don't live in paradise. Good laws make good life possible. I think this explains the first layer of the resonance of Julie's wonderful pieces that surround us. Julie has taken heroes of the law, of justice, of good governance. Bader Ginsburg, most centrally to this exhibit, more on her, much more on how she fits into this story shortly, but also those who have shaped the laws through institutions other than the court, like Abraham Lincoln. She reflects these contributions of justice back to us through beauty and through artistic innovation. She's taken the nobility of law and made it beautiful in the way that only art can. If this were where the story ends, we'd have a very poignant narrative. To live in this world, we need laws that advance the cause of justice. So that the true heights of human flourishing, like art, can be pursued. Julie's work and this exhibit is an homage path-breaking jurist who opened the doors for so many, but whose courage was needed only because of the already present existence of injustice in the world. It is a marker of Justice Ginsburg's legacy that we can come together today in a society marked by greater equality and by greater justice. But there's more nuance to this story. Ginsburg wasn't just an activist or an advocate. Early in her career, she fought for women's rights as both of these. But her legacy has been forged as a jurist, as a lawmaker on the court. What does that mean? We celebrate her centrally today as a creative interpreter of the law. And this is where the plot thickens, trying to draw a connection between law and art. Maybe the legacy of Ginsburg and the pursuit of justice for which she stands has more to do with artistic creation than it seems. Particularly given Justice Ginsburg's legacy as a bold, creative thinker who forged new paths. She didn't just mechanically advance law, she didn't just replicate what had done before. We don't tend to remember those jurists. Nor did she simply follow her moral intuitions on a case-by-case basis. That makes for satisfying outcomes in the moment, but it rarely leads to sound law, because sound law is part of a broader, interwoven narrative. Judges have to do their great challenge. There's a phrase that sticks with us from tonight that I think is represented both in Ginsburg's work and in Julie's art. It's the idea of creative restraint. Creative restraint. The aims of the law cut across the spectrum of the human world. And fairly enough, they are at their most urgent and most vivid when the circumstances are most troubling. When the vulnerable are oppressed. When grave injustices are inflicted. When oppression is perpetuated. The actual act of lawmaking, what judges have to do when they're on the bench and they make decisions, involves balance, involves careful contemplation, synthesis of values, and a keen discernment of competing claims. This is far more majestic, and I would say far more beautiful than we might initially expect lawmaking to be. Why is this? Well, a very high level of abstraction. When judges advance principles, write opinions, and resolve cases, they have to obey, above all else, rule of law neutrality. Fairness with disinterest. Justice brought forth with dispassion. Whenever it is pursued fairly, the making of law by judges is a noble but somewhat austere endeavor. Judges must seek justice not only for the parties before them, or like elected officials. They must not only placate and do the will of those who have selected them, but judges must serve in this way that is irreducible the fairness of an outcome. Now, there's a huge amount of academic debate about what neutral justice seeking should look like. And in the Q&A afterwards, people want to get down and dirty. We can talk about H.L.A. Hart's rule of recognition, or Lon Fuller's 8 principles that are a prerequisite for the rule of law. But I prefer you guys remain awake, at least until I've finished my remarks. So I'll pause on that for now. What I can say with confidence is that this process is inevitably creative. Judges have to make nuanced, sometimes incommensurable decisions. They have to balance the weight of the past. Respecting precedent is the heart of the common law. And the higher law of our now increasingly ancient Constitution. We're here because of the America250 Constitution is this enduring thing in our society. And it is that enduring thing that is the basis of our Constitution. The past of the common law and the ancient Constitution have to be balanced with the needs of the present, justice for the parties who are before the judge, and with the implications of what that holding will be for the future. The special skill of judges is getting this synthetic balance right. Facing the complexity of a society that looks to them as exemplars of principle, and to litigants that come before them in the most tragic, weighty, in urgent moments, seeking justice. Thus, making law requires, and I'll come back to this phrase, creative restraint, second phrase, more indulgent for me, a soft touch. Good judge isn't doing arithmetic. They're in fact doing something that's inexpressibly, insoluble, reflective of the human spirit. Now, I think what I'm about to say, sort of an inflection point in my remarks, is not a surprise. This capacity to capture the inexpressible and the insoluble, this ability to do a synthesis that can't be reduced other than doing it right and beautifully. It's the same nigh-magical balance that artists have to strike. Both are acts which can't be expressed other than doing them right. For art, the result of this getting it right is aesthetic power. And just pause for a moment. We stand in its presence. Look around. We're surrounded by it. How often are we surrounded by this type of beauty? And that's because Julie has this soft touch, this irreducible skill. When judges demonstrate this irreducible skill, the result is justice. What I'm going to turn to now is how Ruth Bader Ginsburg epitomized this capacity for justice. And I'm going to connect it a little bit to how Julie has done the same with her art. Now, I'll start by recounting a little more precision how judges ensure they do justice. The best account, I see some of my students in the audience who are going to blanch at this because you guys are getting like a 2-minute version. They had like 2 hours of this, so count yourself lucky. The authoritative account of how judges do justice through moral interpretation. For those of you keeping score at home, the work is called Law's Empire by Ronald Dorgan. What does this moral interpretation mean? Judges don't simply mechanically reproduce what is done by judges before. Not only is this too mechanical and risk leading to injustice, simply unsatisfactory is explaining how hard cases are decided. Judges face dilemmas all the time that can't be explained mechanically. They have to decide between incommensurable values. Do we favor the preferences of the Democratic majority and respect the majesty of democratic self-determination? Or do we protect the vulnerable minority that might be disfavored by that majority? How do we decide? These are two precious things in a democratic society that also respects equality. How do we balance those? A more humble example. A poor party has been forced into a contract by a ruthless negotiator, but they did agree to the formalities of the contract. Do we enforce that contract? These are not questions that are easily answered and can be reduced further than doing justice. Simple replication doesn't work. But nor can we have judges who just follow their moral intuitions for each case before them. This would make law unpredictable. It would render it subject to nothing but the moral intuitions of lawyers. And guys, I know a lot of lawyers. We do not simply want to be beholden to the moral intuitions of lawyers. We want something more stable than that. So what judges do is synthesize these demands. Instructions from the past, Constitution, prior cases, commitments of the Democratic majority, and the moral demands of the case before. This is the defining property of interpretation. The authority of existing law. Respected, but working within that constraint to reach a just outcome. This, again, yields justice that is constrained but innovative, creative restraint. It's a fitting idea for this wonderful exhibit, whose themes and title, generations, I think, reflect these competing, incommensurable values. Generations looks back into the past, to what has been done, to heroes from our society. But it also looks forward. It is also about generation, about generating a more just society for the future. Ruth Bader Ginsburg's legacy is an emblem of this creative restraint, and of a moment when the possibilities of such creative interpretation were presenting a truly remarkable way. Ginsburg's formation as a lawyer occurred during one of the most radical transformations on how the Supreme Court, the federal bench, could engage in the process of moral interpretation. In the latter half of the 20th century, beginning with the Warren Court, the court began to adopt an especially assertive vision of how moral interpretation could be the leading light of American law and of making sense of the Constitution. This is a decisive point in American lawmaking, and an expression of the idea of what progressive scholars have come to call the living Constitution. It was this shift that cleared the path to cases like we all know, like Brown versus Board of Education, great hallmarks of equality, and led to principles like one person, one vote, that demanded that every person in society have a minimal baseline of democratic authority. This move to the living Constitution turned the court into an institution that was more dynamic, more robust in the pursuit of the vision of justice. Ginsburg took this spirit of the living Constitution and championed it in new directions. This is most vivid in her legacy as a champion of gender equality. This drove her early path-making career that I already briefly mentioned as an advocate for women in the legal profession and the world more generally as part of the ACLU Women's Rights Project. But it's even more powerfully remembered for her time on the Supreme Court. She is best remembered for her decisions, her watershed opinions on gender equality that established that gender faces demanding examination by the court. The phrase is, I think there's an elegance to this phrase, gender classification to survive before the court, it must pass an exceedingly persuasive justification. It's a very elegant formulation. The case that most vividly marked this, U.S. versus Virginia, rejected a blanket ban on the acceptance of women to the Virginia Military Institute. And this case, and the reasoning behind it, exemplified Ginsburg's view that capabilities, rather than stereotype, should drive the opportunities that we have in a free, democratic, and equal society. By the way, if I want to talk more about Ginsburg's jurisprudence, I'm happy to do that. I see during any Q&A or follow-up, I see one of her other great opinions. This is something I didn't even see this until I came in today, but Julie has a work on U.S. versus Windsor, a case that advances marriage equality and gender before the Supreme Court. We can also talk, my specialty area, election law, Arizona State Legislature versus Arizona Independent Redistricting Commission, and the nuances of if the legislature or the state constitution determines the scope of redistricting. But I'm seeing some restlessness from the audience, so I'm going to leave the Arizona State Legislature aside for now. Now, Ginsburg's championing of women's rights is well known. It's one of the reasons she's a hero. But I'd like to draw out a more subtle feature of her jurisprudence that I spent the first half of the talk discussing. Ginsburg did not merely impose a view upon the world. Rather, she synthesized a moment of social transformation through our constitutional tradition. She recognized that discrimination and classification on the basis of sex and gender was ripe through revisiting through the constitutional structure and drawn the arc of a rising tide of equality-focused jurisprudence. But she did so integration of this aspiration through a constitutional architecture that had aspects that were both fixed and malleable. The fixed points are the pole stars of our nation: equality, individual right, dignity, individual right, and the power of democracy informed by a commitment to equality. I guess somebody just tell me if that's approval or disapproval. I'll take it as neutral in the absence of other feedback. The more malleable point, the malleable aspect of what she did, she recognized a particular moment where she could drive the law in a given direction to have the greatest lasting impact in a way that fit into our constitutional tradition. She advanced equality into new terrain. Her innovation was working within a structure to substantively transform our idea. Now, this is all to say that Ginsburg engaged in a great project of interpretation. She identified an opportunity for just change and advanced it through a morally nuanced reading of existing frameworks and dynamics, and did so in a way that respected constitutional and democratic norms of the people the Constitution itself is meant to serve. She identified a moment of constitutional understanding, the greater pursuit of equality through robust constitutional interpretation, and applied it to a neglected area of great urgency, gender equality, and did so in a way that reflected the competing claims of popular authority over policy and the individual right to fair treatment. She was a central actor in the innovation of the concept of intermediate scrutiny applied to gender classifications, which advanced equality without excessively disrupting intrusion into policymaking through accountable democratic bodies. The balancing act Ginsburg undertook is the epitome of moral interpretation. It occurs within the sweep of law, not merely within a single case. But interpretation doesn't only apply to law. Also is, of course, present in the world of art. Interpretation provides a way of understanding art and provides artists with a means of dialogic engagement with an artistic tradition and their aesthetic vision. The world of art, like the world of law, was undergoing a great upheaval during the second half of the 20th century. To make a long and fascinating tale very dense, begun at the beginning of the 20th century with the birth of modernism and abstract representation, was ascendant at the same time the Warren Court was transforming the law. It had a move towards non-representational art as ascendant, from Jackson Pollock to Lee Krasner to Andy Warhol. Dare not step too far outside my bailiwick, but I cannot help observe that the broad transformation of lawmaking, which Ginsburg was an epitome, living constitutionalism, the court as an organ of social progress, corresponded to a moment of artistic radicalism, where classical representation was overshadowed by raw, expressive, conceptual art. The boldness of the court was matched, and I think inevitably surpassed, by the rejection of traditional artistic matters. But courts, when they do justice, are more restrained than artists must be. The proper discharge of the judicial role has an intrinsic respect for, not deference to, that which has come before. Law, when it is a practice of upheaval, must undertake that upheaval to conserve what it can of precedent. Interpretation in law is necessarily preservative of the virtues of the past. This constrains lawmakers, but this constraint can also be a virtue. It forces procedural elegance in lawmaking, as well as firm recognition of the background against even the boldest lawyers. Ginsburg showed this capacity with technical care and analytic precision, even as she advanced the nobility of gender equality. And she crafted a norm that worked within the constitutional architecture, as well as the spirit of the times. Again, reflective of her interpretive power. I think I'm going to try again not to step too far outside my expertise here. The finest art likewise has a soft touch. The soft touch of justice that the finest judges achieve. The soft touch, whether in law or in art, is about the ability to synthesize and balance. This skill of synthesis is present in legal interpretation, but it's also present in art. It has an interpretive excellence that cannot be mechanically reduced. There's a balance in both good art and good law. Moral for the law, aesthetic for the art. Though I think at the highest levels, and we're lucky to see this today in Julie's work, they can come together. So wonderful about the exhibit here, about the art that surrounds us, its themes and in its execution, is that it achieves such a balance. To return to the idea of generations, Julie's work like excellent law, balances a legacy of innovation and of transformation. It recognizes and honors the past, even as it reconceives them in beautiful and dramatic ways. She strikes a balance between abstract expression of ideas and representation of the familiar in ways that the finest artists do. This inspires us to reflect upon the art in ways that bring forth its critical complexities and the critical complexities of the subjects. Julie epitomizes the soft touch, bringing forth beauty without obscuring or lessening the complexity of a subject or of the mode of art itself. It really is quite magnificent. Julie's soft touch is the same synthetic power and creativity that marks the finest of lawmaking. Treatment of subjects from history and on the matter of justice employs aesthetic power while elevating rather than obscuring or distorting the humanity and contribution of her subjects. This is an admirable mode because it raises the art and the subject of the art above all else. In an age of formalism, it's easy to fall into pure method and allow the ego of the artist to dominate. Julie has avoided that. She has a magnificent, distinctive style, like a good judge, that is marked by its subtlety and its synthesis. Reconciliation of substance with aesthetic beauty. All of this is to say, Julie is not only a wonderful artist, an interpreter of art, of history, and the law, but she is a unique synthesizer. It's appropriate for someone who can walk in the world of law and the world of art as few can. Her work reveals the critical eye, one who perceives and builds upon content, aesthetic and moral, while simultaneously bringing her own aesthetic vision to the fore, not to obscure, but to illuminate. As such, she is the perfect complement to Ruth Bader Ginsburg's legacy that did the same through legal interpretation. And we're very lucky to have her work before us. Thank you.